Thank you for viewing this ASSP-sponsored webinar, The Legal Side of Safety: What You Didn't Learn in Training. Thank you to Veriforce for presenting the webinar and providing this valuable information. While this webinar has been pre-recorded, our presenters will be available in the chat to answer your questions. Just a little housekeeping before we get started. We will make this webinar recording available on our website under free learning resources. Please look for our follow-up email with more information on this. Now, without further ado, we will turn it over to our presenters.
Welcome to this month's webinar, sponsored by Veriforce, The Legal Side of Safety: What You Didn't Learn in Training. My name is James Junkin, and I'm joined with my good friend, Brett Kettelkamp, with the firm Ogletree and Deakins. From a logistical standpoint, before we begin, if you've registered for this webinar, you will receive the recording of this event via email, and you can submit your questions anytime. As I said, my name is James Junkin. I am the Chief Executive Officer of Mariner Gulf Consulting and Services. I'm also the Chair of the Veriforce Strategic Advisory Board and the Assistant Administrator for the Training and Communications Practice Specialty. And joining me is Brent Kettelkamp, Shareholder Attorney with Ogletree Deakins. Brent?
Hey everyone, it's really nice to be here, and I'm excited to connect on this really exciting and interesting topic here today.
Thank you. You know, as a practicing safety professional, one of the things I've always felt that we could improve upon is our general understanding as practitioners of the legal aspects of occupational safety and health. And often in our training, these really don't come up as far as coursework or things that are part of our professional development until we have an event. So working with Brent today, we've come up with this presentation to talk about really not an exhaustive list of all the items related to the legal side of safety, but some things that we believe based on our practices that safety professionals should be aware of. So today we're going to talk about knowing what you're signing, your master services agreements, your contracts, indemnification and hold harmless agreements. We'll go over the fundamentals of attorney-client privilege, what safety professionals must do after a fatal accident. We'll discuss legal readiness for events such as wrongful death and gross negligence litigation. We'll give you a few tips based on mine and Brent's experience going through OSHA inspections, about being prepared for OSHA inspections. And we'll close out with a discussion on winning the OSHA informal conference. So that's a lot of information. I guess each of these could pretty much, Brent, be a webinar into itself, right?
Absolutely. I think, James, you and I have talked about these topics ad nauseum, and I agree this could all be topics in and of themselves, but hopefully today we'll provide kind of a general overview of some of the high-level details of these topics. And I will say, just as what would be a presentation by a lawyer without a legal disclaimer. So I'll just say that my comments today are not meant to be attorney advice. And if you do have specific questions, comments, suggest and highly recommend that you reach out to your favorite lawyer, and he or she can help you answering those questions. And my comments here today are just to provide helpful commentary and general comments on some of these topics.
Well, thank you, Brent. So let's jump into it. You know, as a safety professional, contracts seem like that's the area of procurement, or that's the area of the lawyers and attorneys in drafting the agreements between us and our hiring clients, perhaps us and our subcontractors, but they have a huge impact on safety. Let me ask you a question. What is the biggest risk you believe safety professionals have when it comes to MSAs? What should safety professionals be looking for from a safety standpoint in master service agreements?
I have a few, but I think the biggest one that I think is very important for safety professionals to look at is a lot of times in master service agreements, you'll see buried in the language two things. One is indemnification language, and two, safety terms and safety obligations. And I think we can break those down in a little bit more detail, but those are the two pieces that I see that I think safety professionals need to pay specific attention to in looking over these agreements. And first, the safety aspect. A lot of times you will see in MSAs that there are certain safety obligations and requirements, whether you're a hiring client or the subcontractor. And a lot of times, as the hiring client, you have control over these MSAs and you have the control to determine what is included, what safety obligations and requirements that you are going to press down or push down on your subcontractors. And on the flip side, if you're the subcontractor, you need to be aware of what you're signing, what safety obligations you have, and what safety obligations that you will have to comply with or be ready able to comply with. So that's a key one from a safety perspective. And James, I know that we both have had occasion to look at these in recent future. Looking at from your perspective as a safety professional, and specifically on these safety terms, what have you seen important features for these safety professionals to look at and to make sure that their customer or client knows about and is can anticipate?
I think a lot of times what you're finding is an extension of the master services agreements are becoming more detailed as to what the requirements are and the expectations are from a safety standpoint. You will see language inside, if not the contract itself, you will see it as addendums to the contract of what I would call special safety conditions, which means, hey, not only are we going to comply with all federal, state, and local regulations, there's also some client expectations. Very commonly, those client expectations come in the form of things like safety orientations or induction programs. But more and more, we're starting to see contractual language that deals with, for example, the tracking of leading and lagging indicators, the responsibilities of a contractor to the hiring client in regards of managing subcontractors as far as pre-qualification is concerned, continued qualification. So there's been an ever expansion, if you will, related to safety in the MSAs, and I really encourage safety professionals to get involved in the contractual side of this when the negotiations are going on between the yourself as a contractor and the hiring client, or a contractor dealing with a subcontractor. You and I have an article that's out that sort of addresses some of these issues related to master service agreements, as standard indemnity and hold harmless language, for those members that are viewing this, that are members of the American Society of Safety Professionals. This should have been in your September 2025 issue of Professional Safety Journal, and it's entitled Limits of Standard Indemnity in Contractor Injury Cases. And what I found to be very surprising is, Brent, just because it says we're not liable, that does not necessarily make it so. So flipping it back to you, some real world scenarios. Can you offer any type of real world cases that where you've seen poorly worded indemnification and hold harmless language end up not transferring liability like it was intended to do?
One of the first issues that I see in indemnification agreements in certain circumstances is the inclusion of language that violates particular state laws. And so there's a lot of times where you see what appears to be a very robust indemnification provision, but state law may specifically prohibit it. And it depends on the particular court or the jurisdiction you're in, but there may be courts that say this entire indemnification may be wiped out. And so you're left with a blank slate, or you're left with what you thought was a robust indemnification provision, but it's now half of what it used to be. And so, again, making sure that your indemnification agreement or provisions are compliant with state law is a big issue that I see when there are customers doing business in different states.
Yeah, I think you and I both have cases in which that's transpired, where we have a global contract between a contractor and a subcontractor, that for a contractor works in multiple states, only to find out the language is unenforceable. So as a safety professional, one of the things I tried to put into our article, encourage folks, is understand what is in your agreements between you and the hiring client, and as a contractor between you and your subcontractor. But really, what I want to do as a safety professional is never to find out if that language actually works. It's kind of like insurance. I don't want to find out if my insurance actually works or not. Why? Because I don't want to have claims. So incorporating some basic safety principles in pre-qualification when we're a hiring client looking at a contractor looking at a subcontractor, is certainly, I think, the way to tie this up as part of a total risk management process. So I know we're kind of short on time. We have a lot of topics, but I'd like to switch over and talk a little bit about the fundamentals of attorney-client privilege. This is something that comes up anytime we have an OSHA inspection in which counsel's involved, or we have a serious injury or a fatality. If you can, as an attorney, what qualifies as a privileged communication?
And again, I can talk generally about the attorney-client privilege, but there may be particular state laws that apply on how you need to go about engaging counsel in the attorney-client privilege. But just generally, the way in which attorney-client privilege can attach is an attorney-client privilege was created as you are seeking advice from counsel on a legal issue. And I think some of the important critical pieces of this, and we can walk through some of the important aspects as it relates to why the attorney-client privilege is important and how you make sure to continue the attorney-client privilege throughout the investigation, throughout documents, throughout conversations. But I think critical as a part of these conversations that you need to be thoughtful about is who's present as a part of these emails. Who's present as a part of these verbal conversations? Are you CCing non-management level employees? Are you forwarding or are individuals forwarding emails to others that was providing attorney-client privileged advice, but that has now been forwarded throughout the organization? And so there are a lot of ways where there's potential risks that are created that may create arguments that the attorney-client privilege was waived by the client by their activities. But fundamentally, it's you're talking to an attorney, you've engaged the attorney for purposes of seeking legal advice about a particular topic. And I think now we can talk a little bit about more so on the investigation specific side of why it's important, and what are the things that people need to keep in mind for that purpose?
Absolutely. I know as a practicing safety professional I think I just finished my 23rd fatality investigation as a consultant, working with counsel and working with contractors and hiring clients and companies going through those terrible times. One of the things I think that helps me do my job is to be able to rely upon a privileged investigation. A privileged investigation. So, Brent, if you could talk about the importance of a privileged investigation, particularly as it coincides with, let's say, an OSHA inspection that's being conducted at the same time.
Yeah, you bet. And James, I think the best way to illustrate this from my perspective is let's provide talk about examples where an investigation is not privileged and what may happen as a result of this. And so let's just say, for example, James, you're doing an investigation that is not privileged, okay? And you're writing down you're writing things, there's a cause analysis that you provide. And the cause analysis says that employer failed to provide adequate training. And that's in writing. Again, I'm not assuming that you would ever put that in writing, but let's just
Sure.
assume for purposes of this scenario that it is. All right. And that is provided to the organization. It's not privileged. Okay. As a part of the OSHA investigation, fundamentally, one of the things that OSHA requests in fatalities or serious accidents that they're investigating are they're asking for the company to provide any cause and analysis documentation that they have provided or any investigation documentation. Because that's not privileged, the organization has an obligation to turn that over. And so we have issues on two accounts. First, it's the OSHA investigation where the employer has admitted in a piece of documentation that their training was inadequate. Okay? So that's an issue from a potential issue from a citation standpoint with OSHA, where you're potentially admitting liability on a particular issue. Now, fast forward to a potential civil wrongful death lawsuit. And that documentation inevitably comes out where during discovery, the plaintiff's attorney asks the employer for documentation regarding their investigation. And that investigation documentation says there was a lack of adequate training. And obviously that document is at the forefront of that case of an employer's admission that they failed to properly train this particular employee. And so that's an example from my perspective about how documentation can be used when it is not privileged. And so as a part of making an investigation privileged, there's a lot of different important pieces that need to be put in place in order to have a strong argument of the privilege as it relates to the investigation from the OSHA investigation standpoint, as well as the potential wrongful death lawsuit. And again, going into the particulars of the attorney-client privilege, what specifically should or shouldn't be included, all of that information, that's a whole nother separate 45 an hour minute seminar, as well as specific advice that you're going to need from your counsel. And so again, here today, just kind of giving some high level thoughts on how to make sure that you're engaging in appropriate relationships and documentations to ensure that the attorney-client privilege continues to be attached. And James, I think it's important from a safety professional perspective. What have you done in your practice when you're engaging with counsel to maintain the attorney-client privilege in your investigations and elsewhere?
Well, one of the first things is if I'm going to be conducting an investigation under privilege, we want to make sure that we have documentation that solidifies the relationship that I'm being engaged to conduct this investigation by counsel, and I'm doing it on behalf of counsel. Simply copying counsel on an email of your investigation is not creating a privilege. So usually we see this in the form of an engagement letter from counsel directed to me to conduct the investigation, and at the same time containing words to place or phrases, sentences to place within the email documentation or reports, etc., that are produced as part of the investigation that marks those products as attorney-client privilege or work product for counsel protected documentation. Now, the reason I think this is super important, we're going to get to that as we get over here and give some actions to take after a fatal accident, is something you said earlier, which is admissions outside of the privilege, can come back to haunt you. And I found it's coming behind several investigations that were done by well-meaning safety professionals in a serious injury, and there's a couple in fatality investigations. They drew conclusions in their written reports early on to the causation of the incident. And upon reflection and a deeper dive using a acceptable methodology of incident investigation and root cause analysis, that was not being found to be the case. But now we've got all these emails out there and text messages and things that are not protected. So as a safety professional, I think probably the most dangerous time is immediately after an incident occurs. So, a little bit of planning, a little bit of education with your staff about pictures that you take, emails that you send, text messages that go in between parties, discussing the incident, discussing potential causation, etc. You should never do any of that unless directed to do so by counsel and only under the seal of the privilege.
And can I jump in, James? And I just want to emphasize something that you just said, and I can't emphasize this enough. I think in our world, we view text messages as an informal means to communicate, and that somehow text messages disappear. Let me tell you, text messages do not disappear and are some of the best evidence that lawyers are now using in cases. I can't tell you how many times that I have talked with clients about making sure that our communications are through email or through phone, and in order to help maintain the privilege. Inevitably, when we're asking questions about, hey, and specifically talking about, hey, don't send any text messages, and help you have your employees, don't have them send any text messages, and tell them not to send text messages. Inevitably, when we have to ask the question as a part of discovery on saying, hey, are there any text message communications, or are there any pictures that were taken on phones? Inevitably, we are getting information off of text messages, and that information sometimes has not been good, and it is pictures that pictures of unfortunately a deceased individual's body, text messages about what they feel could have happened when they weren't there, making assumptions about what happened. So I can't stress what James said enough. Text messages, they come up in investigations, they come up in wrongful death lawsuits. And so text messages are becoming some of the best evidence that lawyers are using, and what evidence that OSHA is using in certain circumstances for proving their cases.
I'll give you another one that's kind of I've seen in our practice, the rise of social media and posting to social media about events that have taken place related to a workplace incident. That's something that's certainly outside the privilege. It's not probative for your investigation. Nothing good's really going to come out of that. So I really encourage safety professionals, as part of their safety leadership training for supervisors and their management, to talk about these things. Because, when the horse is out the barn, it's too late to shut the barn door, right? So this is things that people don't consider that later can be misconstrued later on in subsequent litigation that may file 2 years later after the event occurred. Speaking of incidents, what safety professionals must do after a fatal incident is really uncomfortable to talk about. we never want to be in that particular situation. But I like to say it's too late to start drawing things up in the dirt once you've had an incident.
You bet.
You know, proper planning on the critical actions that safety professionals are going to take, that companies are going to take, helps prevent adverse outcomes later on, and particularly in OSHA inspections and subsequent potential litigation. So let me ask you some questions related to this from an attorney standpoint. The importance of securing the scene from an evidentiary standpoint. What advice would you give to safety professionals for securing the scene?
Lock it down. Lock the scene down. There are potential claims that can arise, and this is a legal phrase of spoliation of the evidence. And that's effectively saying you took things from the scene, you adjusted or manipulated the scene for a better outcome or to hide things. And so locking down the scene, preserving the evidence, and a lot of times you're going to get assistance about preserving the scene from whether it's from local responders. And local responders have the experience of locking down a scene and preserving the scene, but you have to make sure that the scene is preserved and not disrupted.
So I would echo that. I've had numerous cases where the state police have come in to investigate, or the county sheriffs have come in to investigate surrounding a workplace fatality, and they turn the scene back over to the safety professionals and to the company. And just because they're done with their investigation doesn't mean that we've even begun our investigation. And then, you know, OSHA's notification process, we'll get to in a moment, they certainly do not want any spoilage of the evidence that's there on scene. So this next portion kind of goes together, 2 and 3. Coordinating notifications. Now, we all know that in the event of a fatality, we have 8 hours to notify OSHA, or if you're in a state plan, the state plans that are there. And I used to count on that time, Brent, in the past to be able to get organized with clients, then make our notifications, make sure we have counsel, you know, get some planning done. But of late, I've actually seen the local first responders make notification to OSHA. They called OSHA. Then OSHA called us to ask about the incident. And so I think that's 100% another reason why pre-planning, knowing what you're going to do, who's going to contact OSHA, who's going to make notification to counsel, having that all lined up prior to any of these incidents occurring is absolutely paramount in protecting the organization and conducting an investigation that's privileged. Any thoughts on that?
I can't agree more. And James, I think in particular, what I think is absolutely fundamental to this process is first, like you said, having a policy and a process in place about what you're going to do when OSHA comes knocking at your door, or what you're going to do if there is a serious accident or fatality that requires a report to OSHA. And it's not just having a policy in place. It's not just having a process in place. It's training individuals who are going to be involved on the process. And I have had scenarios where you can have the best policy in the world. You can have the best process in the world, but if people don't know about it, it's absolutely useless. And I've had certain circumstances where we have had OSHA walking around a facility for 20 minutes before someone stops them. And it's because there was lack of adequate training on the first person that meets OSHA, right? It may not be your safety professional. You may not know that OSHA is coming. Sometimes you will, because you will coordinate it. But there's sometimes where you will not know. And the first person that meets OSHA may be the person that answers the phone, answers the doors. They need to be trained on the process of what you're going to do. Of, hey, if this person comes, you're going to sit them in a room, you're going to contact your safety professional, your CEO, and your legal counsel. Make sure that OSHA knows that you're going to be responsive and available, but you want to get your ducks in a row first. But training is so fundamental to this process. And it's not, again, emphasize it enough. I can't emphasize it enough. It's training all the way from all levels of the organization. And it's who is the first person to come into contact to OSHA, to more strategic on who's going to be speaking with OSHA. What are you going to talk about? How are you going to lead them across the scene? All of those are fundamental pieces, but again, just training on what that process is going to look like can help immensely.
And I feel that's best done, Brent, when we're not under the gun. We're not responding to the immediate tragedy of our coworker, someone we care about, someone we're responsible for being killed. That's really not the time and place to try to be putting together a plan of action. This wasn't a fatality case, but we did have one on the East Coast probably about a year ago. Gentleman fell from a roof, not wearing fall protection, was injured. Fortunately, not severely, but he was injured before the company can make notification. In fact, before the company could even get senior representatives there, someone made a call to OSHA, and the area office wasn't far from this site. And they showed up while the individual was being loaded into the ambulance. So at that point, it's too late to try to coach people up on what their rights are, what the company's rights are, how we're going to go about conducting this investigation. The other thing I would say about coordinating notifications beyond just the aspects of OSHA is having a plan. Who's going to speak to the media? That's why I'm 100% in favor of having counsel like yourself and other qualified attorneys lined up ahead of time. So we're not going through the phone book to try to get advice. We're not Googling who handles these type of matters. We have a relationship that on the worst day of our lives, we know how we're going to respond to OSHA, how my employees are going to respond, how we're going to handle the investigation. Are we going to do a press release? If we are, who's going to manage that process? Who speaks for the organization? What's our social media policy? Depending on the event, you may have news media there trying to interview workers and witnesses that witnessed the event. I've seen that here recently. So again, that's all about coordinating efforts in order to have some organization, be respectful for the deceased family, while at the same time preparing for the subsequent investigation that's going to come from OSHA and potential litigation. Now, we've talked a lot here about protecting the company. I'd like to shift focus just a little bit because I've worked with you on a lot of cases, and I think I know I can speak to your heart in this matter. I know my heart in this matter. While we're doing all this, it's not in disrespect to the person who lost their life or the person who was seriously injured. And that's part of the pre-planning process too. How we're going to support those workers, their families, through these troubling times. Brent, I've seen a lot of companies that just wall in, build a fort around themselves. They don't speak to the families. So what advice would you give safety professionals and companies about if we had a serious injury, we have a fatality, about how to go about supporting those while still being cautious in those dealings?
Yeah, and I agree with you, James. And I think a lot of I think this is imperative on how employers treat their employees. And I think this goes to speak of how well some employers do at helping their employees through these difficult times. And a lot of times you'll see where good companies have really good EAPs. They have good counseling services. There's if people are of faith, there's pastors or priests or what have you that are made available to these individuals. And what does this show to the employees about after some tragic event? That this employer cares, right? And they're hurting just a lot, just as much as the other folks are hurting in their organization, and they're trying to help them process and um and just grieve through this process. And a lot of times you'll see great organizations really show how much they care about their employees in these really, really tough times. And it's through providing services, providing opportunities, allowing individuals to go to the funerals, allowing them the time off that they need. All of those types of things are what good employers have done and shown that not only that they care, but because they feel like it's the right thing to do. And those are a lot of things that you see employers do in these types of circumstances. And it's uh, not making sure, also making sure that you're being strategic from a process, and making sure that you're not doing something that's going to potentially give rise to potential claims. So it's being strategic in that sense, but it's also showing your employees that you care and that you're providing them with the services that they need.
Absolutely. And I think in summary, it kind of goes back to pre-planning, having a plan on what steps we're going to take in the immediacy of an incident, particularly those involve serious injuries and fatalities. All right. Now, this is something normally we talk a lot about, Brent, OSHA investigations as safety professionals, but I'd like to shift focus a little bit, because wrongful death and gross negligence claims often come on the heels of OSHA inspections. OSHA inspections tend to be, open in the immediacy of the event. Certainly, OSHA is going to come out and begin the investigation sometimes within hours of the event, no more than days of the event, and they should have that wrapped up within 6 months. Wrongful death and gross negligence claims are actions filed in civil court. Typically, I know it varies by state. How long do plaintiffs have to file these type of claims?
And just to give kind of a high level of, I know there's a lot of employers that think that they were not in the wrong, and they very well not have been in the wrong as it relates to potential fatalities. But the issue is inevitably, I've seen a ton of circumstances where wrongful death claims are filed, and you have to be prepared for a potential wrongful death claim. And a lot of times, this isn't on employers' radars because they're dealing with the initial OSHA investigation. But on the back end, to James's question, sometimes employers have, sometimes there's a 2-year statute of limitations on when you need to file a lawsuit. Sometimes it's 4, sometimes it can be even more than that. And so there is a long process and a waiting game, so to speak, in some circumstances about whether or not a plaintiff or a plaintiff or a family of the deceased or of the injured person files a potential wrongful death, gross negligence type of claim against the employer. And so it's a waiting game in some circumstances.
So these terms, negligence, gross negligence, these are legal terms, often unfamiliar to safety professionals. In our training as safety professionals, we know that workers' compensation is an exclusive remedy, right? Meaning workers' compensation is designed to compensate the worker, to make them whole, to get them back to work, and to avoid courtrooms and litigation. But it seems when we get to these ideas of negligence and gross negligence, to a layperson, what's the difference between a negligence claim and a gross negligence claim?
And James, you're absolutely right. And a lot of times, the thought is that there's a workers' compensation exclusivity, meaning that the only remedy is for this employee to seek relief from the particular workers' compensation statutory framework and agency on a state by state level. But there are various exclusions that can apply to a workers' compensation exclusivity. One of those being, among others, and again, this is a state law specific type of analysis, but one of those being gross negligence. And gross negligence is a higher threshold than just mere negligence. Gross negligence meaning it was willful conduct. Gross negligence can be, in some circumstances, you knew there was something wrong. Someone told you about something that was wrong, but you still continued to do it. Or a circumstance where someone raised a specific issue about the process, about the equipment, and you didn't do anything about it. And this particular safety concern that was raised ultimately resulted in the incident. Those are types of scenarios that could rise to the level of willful or gross negligence. And there are some states that allow claims, wrongful death types of claims, to proceed even if there is workers' compensation exclusivity, to the extent that that higher threshold or burden is established through willful misconduct or gross negligence. And that's just one of the examples. And there's other states that have other types of exclusions from workers' compensation exclusivity, about fraudulent concealment, for example, a non-injury related torts as well. So there's a whole host of exceptions that could apply depending on the specific scenario.
So I think what I'm hearing from you is, for me as a safety professional, it's important to document. And even though we have an incident and the OSHA case is resolved, that might not be the end of that. And that documentation related to this incident, we probably need to keep someplace secure for a certain matter of time, 2 years, 4 years. I'm a big fan of documentation. We never get rid of anything. Computer storage is cheap these days, but you certainly could be facing a legal challenge and having to mount a defense years after the incident itself. So as a safety professional, training records, hazard assessments, incident investigations, corrective action plans, no one's perfect. We all have areas to improve within our safety management system. But it sounds like the difference between negligence and gross negligence could lie upon intent, maybe. So having this type of documentation, I think, usually comes back on the safety professional. Have good documentation, not only for, and record keeping, not only for the initial OSHA inspection, but for something that may come up down the road, because your counsel is going to depend upon you to provide it.
Absolutely. And the same thing that we talked about is, it's too late to train your employees. It's too late to have a process when there's a fatality. The same thing applies here. It's too late to start doing documentation, to actually documenting your weekly, your monthly audits, your toolbox talks. It is too late to do that. Once you have a fatality, you need to have that process in place so you can have the documentation to give it to OSHA. Because the scenario is, you don't have you're doing it. You're doing verbal safety talks, you're doing your audits, but it's not documented. And all of a sudden, you unfortunately have a serious accident. OSHA asks for your documentation. You say, oh, we don't document that. The perspective that OSHA takes is that likely didn't happen, and if it's not in writing, it didn't happen. And I've heard that time and time again. The same thing applies in these types of scenarios. You need to have documentation on it, because the verbal testimony of, well, we did it, we just didn't write it down, is taken a lot less seriously than actual documentation. So I can't emphasize enough: documentation, like James said.
Well, that kind of brings us into this. This could be an entire, not only hour-long webinar. Preparing for an OSHA inspection could be a seminar based on some lessons learned throughout my career and working with you Brent, and your mentorship. But in the time that we got left, what are some mistakes that you see companies making when they're being inspected? What are some common mistakes they make?
And again, I'll talk about it in the past. Not having a plan, not having a process creates the potential for mistakes. And here are a few mistakes that I've seen as it relates to the inspection. First, you have a chatty employee, and that individual talks about whatever under the sun, makes admissions, points out things that are wrong, points out things that should be corrected, makes admissions. So having a chatty employee is one of the scenarios where um, you cannot take those things back when you're talking to OSHA. And so one of the biggest mistakes is someone that is just chatty. So you need to be strategic on who is going to talk to OSHA, who is going to be attend the inspection, who's going to speak on behalf of the company, and then in particular, if there is a specific incident, map out the way in which you want OSHA to walk to the actual scene. You control that. And so if there's a particular spot or location that they don't need to see, they don't need to see that, and walk them around intentionally to the spot that they need to see. And so whenever OSHA is on site, if there's open and obvious, they can cite you for it. And so if your fire extinguishers aren't hung up, if your fire extinguishers haven't been tested, if your eye wash stations aren't marked, all of those types of scenarios are open and obvious types of things that OSHA can cite you for. And so making sure that you're mapping out the way in which that they are going to take them throughout your facility, another critical piece of the investigation, and making sure that you're limiting your potential exposure to OSHA.
I'll second that. I think the most common mistake that companies make, in my experience, is they inadvertently open the door to expand the inspection. That means we give OSHA more than they ask for. We make admissions, and then we end up getting cited for things that had nothing to do with the reason OSHA was there to begin with. Low-hanging fruit, training. I think one of the biggest misconceptions that I find is that safety orientation, induction training, just because it says it's titled lockout, tagout, does not mean that awareness level training is going to meet the full intent of the OSHA regulations that apply. Not having documented training when we're doing on-the-job training. You see this a lot in construction where workers are being trained through a mentorship or on-the-job training. Still need to have some type of documentation. Those are some of the most common things that I think that companies create problems for themselves in the inspection process. OSHA puts out every year a top 10 most commonly cited violations. They rarely change. They may change in order in which they appear in the top 10, but it's been basically the same list now for as long as I can remember. And my advice to safety professionals, take that list, go down through there and say, is there anything on this list that would give me cause for concern? And try to close those loops. So our title slide here, Proactive OSHA Inspection Prep Essentials. Again, we could go on for a long time. Having a plan, working the plan, conducting regular internal audits and inspections, making sure your workers are trained, making sure that you have the documentation necessary can help prepare you for this OSHA inspection. Now,
Can I make one last kind of final comment on that, James? Is I think
absolutely.
A lot of times employers will say that this accident, while super unfortunate, was because of unpreventable employee misconduct. And one of the critical pieces that I have seen missing in the documentation needed is discipline. and discipline your employees and document the discipline. It is absolutely fundamental and critical for purposes of mounting defenses in these types of circumstances that you have documented discipline. And so a critical piece is documenting discipline. And it doesn't necessarily have to be formal discipline. And it can be an email saying, Brent was not wearing his hard hat today. I told him to put it on and he did. That can be formal notice of and formal documentation of discipline. And it's just a note to the file. It could be as simple as that. It can be a first written warning, a second written warning, termination documentation. But again, document your discipline.
Absolutely. Absolutely. Because that documentation will come in handy when you get to the informal conference. So briefly, in the time we got left, let's talk about how to win at the informal conference by first defining, if you will, what the informal conference is. So what is an informal conference, Brent?
Yeah, thanks, James. So the informal conference is the opportunity for you as the organization to talk about, and let me step back. After the investigation, there's a closing conference. The closing conference, typically what will happen is you will hear from the inspector that they are proposing certain citations, but these citations still have to be approved from whether it's the area director or what have you. Those citations come in the mail. You have specific time frame in which you need to participate, or you have an opportunity to participate in an informal conference. And that informal conference is what we're talking about here right now, is where you have an opportunity to discuss the citations and mount your potential defenses to those citations through either whether it's the company or through legal counsel or a combination of both. And this is the time and opportunity before it goes into formal litigation for you to try to resolve the case with the area director or state equivalent.
So based on your experience, what does it take to win at an informal conference? And winning being defined as either deletion of the citations or reduction in severity and penalties.
And I think the first bullet point, James, that we have on this slide is thorough preparation. Absolutely fundamental to winning. And a lot of times what we have done as a part of the preparation on these defenses is put together documentation about, let's just take, for example, it's a training citation. Putting together documentation that outlines the training that the injured employee had, that the training was reflecting that the training was adequate, also reflecting the training that other similarly situated employees had to document their training, and showing that they weren't just trained once, that they had training throughout their employment and what have you. And so thorough preparation on making sure that you've reviewed the citations, have been able to pull the documentation that will help you for purposes of defending in these specific citations. Preparation. And I won't say this is the case for every single informal conference, but James and I have worked together on a number of times, and putting together a PowerPoint where you're providing snippets of the actual documentation and not actually providing the documents to OSHA has been super helpful to help OSHA see all the documentation, training, and other relevant documents to help give them visual aids to see that the company takes safety seriously and has good defenses to the potential citations that were issued. Because what it does is it informs the agency of what they will be facing if this goes into litigation, and the documentation that we have on our end that we're going to use to defend our claims. The claims that the citations that were lodged against the employer.
Absolutely. And I 100% recommend, if you are encountering a inspection involving a serious injury or a fatality, you absolutely, in my opinion, need counsel. Now, I always believe in any OSHA inspection, you need counsel, but definitely when we're facing a investigation involving serious injuries and fatalities, and working together, counsel and safety professional, to prepare for the informal conference. You know, it's a team approach. As a safety professional, I say this all the time: mitigation is cheaper than abatement. Abatement's when OSHA tells you how to fix it. So what I found is being successful when we come to these informal conferences is having a plan of action. If there was, obviously they're there for a reason. If they're wrong on the facts, we'll present the facts in the manner that we believe the facts were. If they're wrong on the standard or the interpretation of the standard, that's where our counsel and attorneys come into play. But from a safety professional standpoint, without making admissions, what have we done to ensure that this event's never going to happen again? And that includes presenting a well-organized case that's going to highlight how you're bringing your company into compliance, the corrective actions you're doing. Training, retraining workers is always a component of that. But I would say it needs to be more than that. It needs to be more than just a stand down and retraining and et cetera. You know, what are you taking from a safety management systems perspective? Even if it's improvements outside of what caused the event, showing investiture into your program, financial commitment, management involvement. These are all things that I believe area directors look at when you come to an informal conference and ask them to delete, reduce, et cetera.
And James hit the nail on the head. I have been told time and time again by area directors or agencies that what they're looking for in these informal conferences, they're looking for exactly what James said. And they have to be in a position to justify why they're either deleting or reclassifying citations. The way that they will justify it is through exactly what James explained. And so that's a absolutely fundamental piece to the informal conferences, having your safety professional be in a position to explain what you have done and what you are doing and what you will continue to do. And I always tell folks, I'm not a safety professional. I'm a safety lawyer. And your safety professional is absolutely fundamental to the process of helping explain how you're doing it, what types of plans, processes, procedures you've put in place, what additional training has been done by your safety professionals to hopefully ensure that an accident like this never happens again.
Absolutely. Absolutely. Well, Brent, it's been a pleasure coming with you and doing this webinar and drawing upon your experience and giving some advice to safety professionals, myself included, on these issues that are often overlooked when it comes to safety law and occupational safety and health. Brent and I have listed our contact information here. If you'd like to reach out to us, there's our email addresses on the slide. But as we wrap this up, any final thoughts, Brent, related to advice that you would give companies and safety professionals with regards to occupational safety and health law?
Happy to answer any questions, and feel free to email me if you have any follow-up questions. But my last piece of advice, I think I can't emphasize more, is making sure you have a process, procedure, and training in place of what to do when OSHA knocks on your door. That is going to set you up for success, and to make sure that you have some process like that and your leadership knows, and every individual that has the potential to interface with OSHA has been trained on your processes. I think that's going to have the best potential to set you up for success.
I echo that. Thank you for your time, Brent. Thank you, VeriForce, for sponsoring this webinar, and thank you for ASSP for allowing us to come and present this to you today.
Great, thank you everyone. We appreciate you being here. Just as a quick reminder, we will make this webinar recording available on our website very shortly. Please look for our follow-up email with more information on this. Also, for those who have attended the webinar, you will receive your CEUs. You'll find this information in our follow-up email as well. Thanks again for joining us today, and we will see you next time.